Hello everyone, I'm George from Ireland. So this is my English law channel, and now I'm going to be looking at unregistered title and land charges, how you can register land charges in unregistered title. Now, charge here is not in the ordinary sense of the word. Charge is in a fee or an accusation. Okay, so we'll look at the machinery of overreaching of equitable interests which are commercial in character, for instance, estate contracts, restrictive covenants, and so forth. Before 1925, these interests were governed by the Doctrine of Notice. That meant they were binding on everyone except the bona fide purchaser of a legal estate for value without notice. This person's known as equity starling. But let's break that down. Bona fide, so good faith purchaser, they're buying it, they're not inheriting it or receiving it as a gift. Of legal estate, it can't be an equitable estate they're buying, and full value. So they have to be paying something like a market price. If it's £1 million, they paid £1 million or more than £1 million, that'd be fine because the market value is £1 million. If it was a bit less, like £800,000, they'd probably still say that's for value. If it was a derisory sum in relation to that, like £10,000, they'd say that's not for value. And without notice, as in he didn't know about the interest that was going to be there, that he was going to be bound by. Didn't know, had no reasonable way of knowing, things like that. His agents didn't know either. We'll come on to what notice is: actual notice, constructed notice, imputed notice, and so forth. So the purchaser had to make some inquiries, had to go and look at the land. So to rule out any need to do this, the Land Charges Registration System was established in 1925, and the Land Charges Act was passed in 1972, which replaced the 1925 LCA. The LCA 1972 allows for the possibility of registering of certain land charges against the name of the owner of the land in the Land Charges Register. Notice it's not against the name of the estate, the name of the piece of land, the house or the farm or whatever. So the land charges are spelled out per section 2 of the LCA 1972. And this is what matters to us. And these are the ones that really matter to us: a puny mortgage, class C1, a general equitable charge, class C3, an estate contract, class C4, a restrictive covenant, class D2, an equitable easement, class D3, or a spouse or civil partner's right of occupation pursuant to the Family Law Act of 1996. That's a class F land charge. So a land charge is, as I said, registered against the name of the owner of the estate. So the registration of the land charge means that's actual notice to everybody. Even if you didn't look at the Land Charges Register, well, that's your silly fault. It's assumed that you had notice. So this protects the interest when the land is sold, and that's put in as per section 198 of the LPA 1925. But if the land charge is not registered before the purchase is completed, the effect is contingent on the kind of land charge and the characteristics of the purchaser. That's as per section 4 of the LCA 1972. Now, this means that an estate contract, a restrictive covenant, or an equitable easement will be void for non-registration against a purchaser of legal estate for money or money's worth. But a puny mortgage or a general equitable charge or a spouse's right of occupation of a matrimonial home will be void for non-registration against any purchaser for value of land or any interest in land, whether it's legal or equitable. And this is provided for in section 4. And it underscores that usually it doesn't matter whether the purchaser who buys a legal estate has notice of the interest, is void against it for non-registration. And that's as per section 199 of the LPA 1925. The reason for the Land Charges Registration System is to abolish this traditional doctrine of notice. The authority on how this works is a House of Lords ruling in the case known as Midland Bank against Green, 1981. Anyway, so this decision underscores how important it is that the holders of land charges use this system, or they may well find that their rights cannot be enforced against somebody who bought legal title to unregistered land. So money's worth includes money, obviously, or includes a land swap, or includes something of value. It could be nominal consideration. It could even be marriage. I'll marry you if I get this land. So you will later see how the law applicable to registered title is different, and by contrast, marriage consideration is not regarded as value. Um, uh, anyway, so bear in mind that any unregistered land charge is valid against a person who has received the land as a gift, right? So the land charges registration system is good from the point of view of the buyer, because it means that he or she doesn't need to go and look at the land and ask lots of questions. But the problem from the perspective of their perspective is the registration isn't against the land. Remember, it's against the estate owner. So the estate can be owned by lots of different people, and the land charges keep changing the name. So this means that land charges register against each owner's name. So after the Law Property Act 1969, Section 23, the amount of time you have to investigate the title for to find good root to title is 15 years. Now, this became trickier. It became trickier for the purchaser to find all the pertinent names, but he's deemed to have had actual notice of the land, the charges registered against them. For example, a restrictive covenant registered in 1930 against the name of the estate owner at the time. But if he's bound by such a hidden interest, he might be able to get compensated from the public purse. That's as per the land, the LPA 1969, right? That's Section 25, the Law of Property Act 1969. Okay, so going a little bit more on. So let's go over some of the things that we've learned today. The 1922 and 1925 and 1972 reforms, they changed the enforceability of third-party interest in land. Interest in unregistered land, which have commercial value, can be registered as a land charge, and there's several different categories of those. If there's no registration is executed, then the interest is void against the purchaser for value or money's worth. That's contingent on the kind of land charge it is. The doctrine of notice is disapplied to land charges. So thus, if an unregistered land charge is void, even if the purchaser has actual notice of it. So the system of land charges is problematic. Remember, registration is by the name of the estate owner, not by the name of the piece of land. So that is a weakness, some people think, and that's partly because it was meant to be a temporary measure and nobody's got around 49 years later to coming up with something more satisfactory in the long term. So let's look at the doctrine of notice in unregistered land. So there was a scheme from 1925, and the legislation was that equitable interests would be either overreachable or registrable. The doctrine of notice continues to be relevant to those equitable interests which are outside the scheme. In some cases, equitable interests have deliberately been kept off the scheme. In other cases, the doctrine of notice covers this lacuna because the statutory provisions, just didn't think of it. So some of those interests are going to be, I'll tell you about later on. But anyway, bear in mind that the most important interests are still bound by this doctrine of notice. And these are restrictive covenants made between a lessor and a lessee, a restrictive covenant that was made before 1926, an equitable interest arising under the doctrine of proprietary estoppel, interest held in a constructive trust, equitable interest under a bare trust, a beneficial interest under a trust of land where the interest is not overreached because, for instance, the capital money is paid to only a single trustee. Case in point would be Caunce against Caunce, 1969. Constructive trust and proprietary estoppel interests are very normal, and they're actually being made more and more. So the doctrine of notice is actually more important than it used to be in unregistered land. However, in most cases, the doctrine of notice plays only a slight role, and the purchaser is bound unless, of course, he's a bona fide purchaser of legal estate for value without notice. That's equity's darling, and without notice, he doesn't have actual notice, imputed notice, or constructive notice. Later, I'll give you a breakdown of what those three types of notice are. So the meaning of actual notice is that you really find out. Imputed notice means that you're somebody working for you, your factor, your estate agent who was doing this for you, your solicitor, your accountant or something, had notice of it. If he or she failed to pass it on, well, that's your problem. You can take legal action against them. So constructive notice is more difficult to figure this out. This is when a person has constructive notice of all the facts, and he should have actually found out, he should have had actual notice, but if he made those inquiries and inspections properly. So this is what buying and selling unregistered land is about. Anyway, so purchaser is looking for good root of title. Remember, it has to go back to at least 15 years and looking for all the people who've owned it in that time. So a purchaser has to inspect the land and ask people who are occupying the land what rights they can claim. There's a rule in Hunt against Luck, 1902. The tenant's occupation is notice of the tenant's rights, and the presence of a vendor in occupation doesn't rule out the possibility of it being occupied by others. It could be a huge piece of land. So it's tricky for a purchaser to find out who, apart from the vendor, is living on the land, especially if the vendor is being underhand. He might be meretricious, so he might surreptitiously keep more people on the land, and the vendor might get the buyer to visit at times when other people aren't there. So, but when it's obvious from an inspection that somebody else is there, the purchaser must ask questions of that person. So he can't depend on what the vendor tells them and simply assume it's true. You must propose questions to others who are there. It's unsure what steps the purchaser has to take so he can be sure who really occupies the land. Should he ask neighbours? Should he only look on the electoral register, the phone book, or what? So it would appear that he can't simply trust on inspections made at times that the vendor agreed with. He has to trespass a civil wrong, remember. So he could turn up unannounced and go there himself, see if anybody else is there. King's North Trust Limited in Tizard, 1986, is a leading case on this one. So it may seem bewildering, and indeed it is probably the trickiest part of it. But anyway, so let's go over this. So there are a series of yes-no questions to figure it out. The system is not quite as mystifying as you might have imagined, okay, to work it out. So in unregistered title, are any of these interests going to be binding? The first of all thing we have to ask is the interest legal? And that's under section 1.2 of the LPA, 1925. And if it is legal, is it a puny mortgage, as per section 2.41 of the Land Charges Act, 1972? If the answer is no, it's not a puny mortgage, then it's binding. If it is a puny mortgage, you have to ask, is it registered? If it is registered, then it is binding. Okay, that first question, is it a legal interest? Right. If the answer is no, is it an equitable interest? If the answer is no, it's not an equitable interest, in which case it's not binding. But what if it is an equitable interest? If we say yes, it is an equitable interest, we have to ask, is it overreachable, as per section 2 of the Law Property Act 1925? And if it is overreachable, has it been overreached as per State Bank of India against Sood? And if the answer is yes, then it's not binding. If the answer is no, we have to ask, is the purchaser equities darling? You know, the bona fide purchaser of legal estate for value without notice, as per King's North and Tizard. And if the answer is no, then it's not binding. If the answer is yes, then it's binding. But let's go back to that question about, is it overreachable? If the answer is no, is it registrable? Remember, look at section 2.1 of the Land Charges Act 1972. And if the answer is no, we go again to that question, is the purchaser equities darling? Tizard against King's North. Remember, if the answer is yes, it's not binding. If the answer is no, then it's binding. But we're asking, is it registrable? If the interest is registrable and indeed has been registered, then it's binding. Okay, so that's enough for me on these interests. Toodaloo, goodbye.